Some domain name disputes are just not appropriate for the UDRP, and some UDRP complaints are so poorly drafted that they're destined to fail. Of course, I try to help my clients avoid both of these mistakes. Hi, it's Doug Isenberg, and in this video, I'm going to talk about a couple of cases in which the trademark owners may have made both of these fatal errors, and I'll explain why it's so important to properly evaluate a domain name dispute up front, and then if you do proceed, why it's absolutely essential to file the strongest possible complaint without taking anything for granted. At its most basic level, the UDRP, or Uniform Domain Name Dispute Resolution Policy, includes a straightforward three-part test that trademark owners can use to resolve cybersquatting problems. But even experienced attorneys sometimes fail to analyze a case before filing, or they file an insufficient complaint by not including important facts and legal arguments, which leads to failure, wasting both time and money. Two cases that got me thinking about these issues are RigMinder Operating versus Evan Gooch and Yachtminder Systems, a WIPO decision from January 2021 that involved the domain name rigminder.com, and XTM International Incorporated versus Zhang Hao, a forum decision from February 2021 that involved the domain name xtm.com. Now, the rigminder.com case is an unusual but not unheard of type of UDRP dispute because the domain name was actually associated with the website of the complainant or trademark owner, and at least based on the published decision, was not being abused or misused by the registrant of the domain name. This type of case sometimes arises when a company's domain name is registered by an employee or a business partner, where everything is just fine until the employee leaves the company or partners part ways with each other, which means that the company no longer has control over what it believes is its own domain name. I've seen these types of disputes many times before, and I always start by exploring whether the UDRP is even the right way to resolve an issue like this, where a domain name was registered by someone who had the right to do so, either expressly or by implication, and where the domain name is being used in connection with the trademark owner's own website, it may be impossible to establish the bad faith element of the UDRP. Under the right circumstances, I've filed and won this type of case before, but I always want to explore the likelihood of success before jumping into filing a UDRP complaint. The xtm.com case is also unusual but not unheard of, because it involved a domain name that was registered before the complainant's trademark rights arose. In fact, according to the decision, although the complainant began providing its services in 2001, it only obtained a trademark registration in 2020, claiming a first use date also in 2020, which was 20 years after the xtm.com domain name was registered in the year 2000. Now, usually when a domain name is registered before a client's trademark rights arose, it is impossible to prove that the domain name was registered in bad faith, although there are some narrow exceptions to that rule. In any event, as I often tell my clients, if filing a UDRP complaint is appropriate, then no matter what the facts are in the dispute, it is important to be thorough. A UDRP complaint is much more complicated than a typical complaint in a U.S. court, which emphasizes notice pleading and is really only intended to notify a defendant of general issues in a case. Instead, a UDRP complaint is much more like a motion for summary judgment under U.S. law, meaning that it should include all of the factual and legal arguments, along with relevant citations as precedent, such as previous UDRP decisions, that will allow a panelist to evaluate the merits of the case and make a decision about what should happen with the domain name. Now, the contents of a UDRP complaint are also especially important because the complaint is often the only document that a trademark owner will file, given the streamlined nature of the UDRP process. Fortunately, The UDRP rules and the provider's supplemental rules give parties ample space in which to make out their cases. For example, at WIPO, the arguments in a UDRP complaint can include up to 5,000 words, and at the forum, 15 pages. Plus, I always support my complaints with 10 to 20 annexes that include copies of relevant supporting documentation. As a UDRP panelist, I've had the opportunity to review hundreds of complaints through the years, and although most of them are thorough, I've also seen many that are not, either because they're just poorly written or conclusory. I did not see the complaint in the RigMinder case, but I did read the decision, which makes clear that the trademark owner here failed to make sufficient arguments. While the panelist found that the disputed domain name was identical or confusingly similar to the complainant's trademark, satisfying the first of the UDRP's three-part test, the panelist found that the complainant had not proven the bad faith or third part of the test. In fact, the decision's summary of the trademark owner's arguments make clear that the complaint was quite lacking, noting that there were no allegations or evidence in the complaint to describe the circumstances surrounding the registration of the domain name. No discussion of the actual named respondents in this case, and no discussion whether there is some link between various parties associated with the complainant and the respondent. While the UDRP includes specific examples in which a trademark owner can establish a domain name registrant's bad faith, as I discussed in episode 8 of my masterclass on domain name disputes, it appears from the decision in the RigMinder case that the trademark owner may not have referred to any of these examples and instead simply stated in a conclusory manner that the domain name was registered in bad faith. As a result, here's what the decision said. The panel cannot find bad faith registration and use on this record. As noted above, complainant repeatedly states that it owns the domain name and that its own employees are refusing to release some passwords surrounding the domain name to complainant. The complaint does not provide details about the employees, plural, and their alleged refusal to release passwords to complainant. Further, the complaint does not set forth the circumstances surrounding the registration of the domain name, and so the panel cannot determine whether the domain name was registered in bad faith. In sum, as pleaded and presented, this complaint fails to provide the basis upon which the panel can conclude, under the elements of the UDRP, that the domain name should be ordered transferred to complainant. Now, something quite similar happened in the XTM case, the one in which the disputed domain name was registered 20 years before the complainant's trademark rights arose. The decision was incredibly short in that case, apparently because the complaint must have been quite short too. Here's what the panel wrote in that case. In the case before us, the complaint contains only the scantiest allegations, and the only proof offered in support of those allegations consists of a copy of complainant's USPTO trademark service mark registration. The evidentiary record upon which complainant asks this panel to reach the conclusions necessary to justify transfer of the contested domain name to complainant is therefore woefully lacking. This failure of proof is fatal to complainant's request for relief. So, both of these cases, for RigMinder.com and XTM.com, are good reminders that the burden of proof is always on the trademark owner filing a UDRP complaint, and there is no such thing as a default judgment, which explains why the trademark owners lost these cases, even though the registrant of the domain names didn't bother to submit a response in either case. As I've said before, that's an embarrassing way to lose a UDRP case, so the lessons here are simple. Always evaluate whether the UDRP even applies to a domain name dispute. Never assume anything when filing a UDRP complaint. And be sure to make every possible factual and legal argument to help ensure success. Of course, choosing an attorney with significant experience under the UDRP is a wise decision. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other UDRP cases. Thanks for watching, and see you next time online.